I don't represent causes, I represent clients. And the only thing that ended up mattering to me was whether he was found not guilty or not.
We're going to examine the case top to bottom. Tony Katz and Jason Nichols will tell us if America will learn anything from this. Former FBI Assistant Danny Coulson joins us on whether the verdict inspires more to arm themselves. Civil rights attorney Robert Patillo tells us whether the charges in the Ahmaud Arbery case in Georgia are more likely or less to get a conviction. But we start with Philip Turner and Bob Bianchi, both former prosecutors, current defense attorneys. Gentlemen, good to see both of you. I don't think either of you really are surprised by this. Philip, start with you. Was the prosecutor bad, or did he have a bad case?
I think that he had a bad case. And of course, he made it worse, but he had a very bad case. But then again, the prosecutor knew what his case was, or should have known, because he's able to interview all the witnesses in his office for weeks or months, and then he's able to do practice cross-examination with them, and that's what a good trial lawyer does. And you know the weaknesses of your case, and you know what your case is about, and you can take whatever necessary action you think is appropriate to do something, if not dismissal of the charges, changing the charges, or whatever. But the facts were bad.
Yeah, they certainly did seem bad for that. And in the end, this was the deputy prosecutor, Bob, sort of in the last ditch of the closing argument, the rebuttal closing argument, explaining what Kyle Rittenhouse should have done rather than shoot. Take a listen.
Everybody takes a beating sometimes, right? Sometimes you get in a scuffle and maybe you do get hurt a little bit. That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds, and no, bullets are not bullets.
Isn't the law, though, if you're getting beat up and you think you're going to die and you didn't start the fight, you do get to shoot back?
Death or great bodily harm, Leland. Let me go to the point that you just raised a moment ago with Philip. As a former homicide prosecutor who's really investigated cases and tried them, these charges were brought within days of this incident, before the autopsies, before all the evidence was collected at the crime scene, before all the witnesses were interviewed, before all the videos and photographs came in. We take weeks and sometimes months to dot I's and cross T's to make sure we have a solid case. And so when the defense attorney got up there in summation and said, this was all about politics, they did this because they needed to have a scapegoat, it resonated based on the facts of this particular case. Last point, to Philip's point, did he have a bad case? Did he put on a bad case? He did a lot of bad things with regard to violating court rules, commenting on the defendant's post-arrest silence. We'll put all of that aside for a moment. There wasn't a legal commentator either on the liberal side or on the conservative side that didn't listen to the state's own case, where 4 witnesses confirmed the self-defense claim, including one of the victims, Grosskreutz, who was the one who had the gun and pointed it at or in the direction of Rittenhouse. We were all in shock as to why it was that this case was moving forward. And that is why the prosecutor then asked for the second-degree lesser-included offenses. Let me give you what that means in code. That means my case is going down in flames, and I want to give the jury a middle ground to go to rather than straight at not guilty, because they knew that's how bad the case was going. The facts just weren't there, and that is the issue. And what's sad, last point, is that it's not about narratives.
No, it's not about narratives. That's why we have trials. It's about the facts. And Phil, we talk about the facts, and we alluded to it in what Bari Weiss had to say, is that there's so many folks and people who have, are intelligent and read the news and everything else, who seem to think that there were so many facts here that didn't matter, that he allegedly crossed state lines, or should a 17-year-old be allowed to have a weapon, on and on and on. How do we explain to folks that 2 things can be true at once, in the sense that Rittenhouse is not a hero, and he was probably doing things that at the very least were really, really stupid, but at the same time should be acquitted on the charges he faced?
You can't explain that to them, because they have an opinion before they've heard anything. And so there's no way you're going to convince them of anything or show them anything. The facts here were bad. The prosecution knew the facts, and yet they proceeded with this case, which I think is quite scary, because it shows you that there are prosecutors here who will prosecute cases when they know those cases shouldn't be prosecuted. What the prosecutor should have done is taken the heat and said, you know what, we've investigated this case, taken the time to investigate it, and said, there's a substantial question of self-defense, we're not going forward. And there would have been yelling and screaming, But that's what you have to do when you're a prosecutor. You make that kind of tough call, and that's what should have been done here. The case should have never been charged.
Yeah, as you both point out, the media had so much about this, and it really wasn't until that cross-examination of the one person who Rittenhouse shot who survived, who admitted that he pointed his gun at Rittenhouse, that this really blew up in the national media conversation. Here's MSNBC Today as the verdict came in.
If the message that people get out of this is that it's a good idea to come in the middle of civil unrest or protests with a long gun, that's not the right message, and that definitely isn't the best message, and that shouldn't be the message that came out of this trial.
Bob, agree, disagree?
Absolutely disagree. This is not about messaging. This is about whether or not you violated the criminal statutes of the state. That's the problem. We don't have trials so that we can deliver messages unless it's about deterrence and violating the law. The fact here is 12 jurors, after listening to all the evidence, and most legal commentators that are, again, on both sides of the equation that listen to the evidence, knew that this was potentially a not guilty verdict. When we're sitting here trying to say that a person should be convicted, Leland, my rhetorical question back to my friends that say those kind of things. There are trials happening every day throughout the United States of America that you don't see on TV. Is that the standard by which they want their mother, their father, their brother, and sister to be judged by? If they were charged with a crime, they'd be screaming bloody murder if that were happening.
Yeah, no, it's a great point.
Of course they would. Of course they would.
You know, normally when we have these legal panels, you guys disagree with each other. It's telling that over the entire course of this trial, almost every lawyer we've had on has agreed on these points. It's the political commentators that have the other ideas. Philip Turner, Bob Bianchi, great work over the past couple of weeks. Gentlemen, we're smarter for it, and thank you.
Thank you, Leland.
Thank you.
Good to see you both.